Good morning. You have joined the webinar on how GDPR will transform the disclosure landscape. My name is Ned Mumtaz. I welcome you all to this webinar. We have a very learned and expert panel who has joined us to share the information with you. They bring a lot of legal expertise as well as practical life sciences and pharmaceutical expertise to this webinar. So without further ado, let me quickly introduce to you the panelists. So I have Elisabeth Kohoutek. She's with King & Spalding. Elisabeth is a member of King & Spalding's FDA and Life Sciences practice, and she supports both European and US clients. She'll give a more just bio of her background as she presents her information, but we are very excited to have Elisabeth as part of this discussion. We also have Maite Vazquez Calo as a member of this session. She is an independent member of the board of directors of cooperative group Kajama, and she is also a law partner at AS Law. She has been part of our panel before. She brings tremendous experience and expertise in litigation and arbitration in life sciences industry, and Maite would also provide a more detailed bio of her background when she presents her information. And very quickly, my name is Ned Mumtaz. I'm the practice leader of life sciences at qordata. I have around 18 years of experience in the pharmaceutical industry, working primarily with the drug manufacturers, with various large manufacturers such as Schering-Plough, Wyatt, Eisai, and Otsuka. And it is my pleasure to be part of this webinar today to present to you information on GDPR and how it is expected to influence the landscape of compliance and consent management within EU. With that, what I would like to do is introduce the agenda to you. After this introduction, I will transfer the presentation over to Elisabeth, who would walk you through the GDPR and its expected transformation of the disclosure landscape. After Elisabeth presents her information, then Maite will present information around GDPR with respect to the research activities. I will follow that up with a session on consent management under GDPR. And after that, we will open up the webinar to questions and answers from all of you attendees as well as panelists. So that's the format we will follow. We will run this webinar for exactly 60 minutes. So without further ado, I'm going to transfer the discussion over to Elisabeth, who will walk you through GDPR's expected transformation of the disclosure landscape. So over to you, Elisabeth.
Thank you, Ned. So as Ned already said, I'm a lawyer with King & Spalding. I am located in Frankfurt, Germany, and we are providing advice to clients mainly from the life science industries. So we are supporting clients mainly, the main client base are pharmaceutical companies and medical device companies and manufacturers and distributors of cosmetics and foods. We help our clients to comply with all those numerous regulatory requirements they face, which are the various regulations for those kinds of products, for pharmaceuticals and devices and foods. We are helping them in advertising and labeling issues, in various compliance issues, also, of course, privacy issues, and we support our clients in all manners of IP laws. So we help them with view to trademarks and with view to unfair competition questions, and we counsel them and litigate also for them. And yeah, as Ned said, today we are talking about really pop up my presentation about how the new privacy laws will transform the disclosure landscape. And as you know, in April past year, the EU Parliament adopted the new EU General Data Protection Regulation, the Regulation EU 2016-679. And with the new General Data Protection Regulation comes a number of new requirements for pharmaceutical companies dealing with personal data. After a transition period of 2 years, the General Data Protection Regulation will apply from May 25th in 2018, and it will be directly applicable in all the EU member states. As EU regulation, it overrules national privacy regulations of individual member states, and it covers any processing of so-called personal data. The term personal data is very broad and means any information relating to an identified or identifiable natural person. So it covers any personal data that companies receive from patients, personnel, or contract partners, or healthcare professionals. So what are the main changes that come with the General Data Protection Regulation? As already said, the privacy regulations across the European Union will be the same, and we will reach the so-called full harmonization in privacy law. The competent authorities are drawn much closer and will be cooperating in the enforcement of privacy regulations much closer than under the current privacy directive. So whenever one authority learns about an infringement that somehow inflicts also with another EU member state, it will then immediately cooperate with that other authority to solve the situation. Also under the regulation, the territorial scope of the regulation will be broadened. It will not only be applicable where the processing company has established its business or local branch, but also at the place where the relevant performance occurs. This means that the regulation will also apply to data procedures that actually occur outside the European Union if the data processing is directed to natural persons located in the European Union. Liabilities and penalties for companies violating privacy rules become much stricter, and authorities may enforce much higher fines than under the current privacy regulations. Companies violating privacy regulations also will have much more comprehensive notification obligations. There will also be some changes regarding consent, and natural persons whose personal data are processed get more rights under General Data Protection Regulation. So the regulation, for example, introduces a right to erasure and a right to be forgotten. And finally, the regulation brings more obligations for the processing companies with view to documentation of their data processes, the so-called accountability. So let's jump to the first and I think very important point is the higher fines. I'm sure you're all aware of that, and that competent authorities can enforce much higher fines than they could that they can under the current laws. In case of an undertaking, the administrative fine can take up to 4% of the total worldwide annual turnover, which is quite a large number. And for natural persons participating in infringement, the fines can take up to 20 million euro. This is much higher than, for example, currently in Germany, the fines are. Under the current German Federal Data Protection Act, the fines imposed amount up to 300,000 euros. Maybe interesting for you is that in Article 83, Para 2 of the regulation, there's a catalog of criteria on the calculation of fines. And when you are internally setting up processes and procedures for ensuring compliance with the privacy regulations, it may help you to look into that catalog and to see what would help you, which behavior helps you to reduce the possible fines that could be set to you. So for example, in 83 it says that the cooperation with competent authorities in the event of data breaches helps to mitigate the damage, and that will help to mitigate the damage, then will be taken into consideration when deciding on the amount of administrative fines. So keep that in mind when you set up your processes. The General Data Protection Regulation extends the liability of data controllers and data processors. So with the new regulation, not only a person who has suffered material damages has claims for compensation, but also a person who has suffered non-material breaches. This is new. Non-material breaches were very difficult to obtain under the current regulations. And also the regulation not only established claims against controllers, data controllers, but also against data processors. This is also new. So a comprehensive documentation of privacy practices of data controllers and data processors becomes even more relevant under the new regulation. Only with the proper documentation, you will be able to defend yourself against any alleged claims. So what is the legal basis for processing personal data under the regulation? The central regulation of with view to the legal basis is the Article 6. The overall principle remains that processing of personal data is inadmissible unless allowed by law. And this Article 6 provides those exceptions where processing of personal data is allowed. I picked out the two important for disclosure topics. So here it's the literature A, where it says it is allowed in case the person whose personal data are processed has given consent to the processing. And in C it says where processing is allowed, where it is necessary for compliance with the data, with a legal obligation to which the data controller is subject. So in EU member states where pharmaceutical companies are required to disclose cooperations with healthcare professionals by law, they may do so following from Article 6, paragraph 1c. In this case, processing is necessary for compliance with the legal obligation. In member states where there is no such legal obligation, and the pharmaceutical companies disclosing data in order to comply with an industry code of an industry association the company is member of, the company may only do so if the healthcare professional has consented to the disclosure. So what kind of consent do we need? A consent must be given freely, it must be specific, informed, and it must give an unambiguous indication of the healthcare professional's wishes by which he or she, by statement or by clear affirmative action, signifies agreement to the processing of its personal data. This means that the healthcare professional must have a real and free choice of giving or not giving the consent. He must actually be in a position to not give the consent without suffering any negative consequences. He must be fully informed for which purpose he gives the consent, and the data may only be used for this specific purpose the healthcare professional gave the consent. And the consent must be obtained prior to disclosure. So this means whenever you want to process personal data and you need a consent, you must ensure that you inform the person you are seeking the consent from fully. So the person must know what data are collected, for what purpose, and what are you going to do with that data. The pathway of those data must be completely traceable, and the person consenting must be aware of that. You must also know whether those data stay in the EU or whether this data shall be transferred to another country, for example, to the US. There is no specific form a consent must have. The regulation only states that there must be a clear affirmative action that signifies agreement to the processing. However, with view to the burden of proof and the documentation requirements imposed by the regulation, it's strongly recommended to obtain a written and explicit consent from the healthcare professionals. You have it in your files then and can show it whenever you need to defend yourself. Any consent given under the current data protection directive remains valid. Pharmaceutical companies do not have to obtain new consent as long as the data are processed in compliance with the consent given. It is important that in case of a written declaration, the declaration is distinguishable from other matters in that declaration, and that is intelligible, easy accessible, and in clear and plain language. So when you have, for example, a contract, and in this contract, or in connection with this contract, you need also a consent, the best practice is to have the consent form on a separate sheet, not to have it somewhere hidden within the text on one page within the whole contract, but to have it really as an annex or as a separate document on a separate page, so that the person consenting really is aware of all the circumstances and that it is really distinguishable from these other matters and from that other declaration. Withdrawing consent must be as easy as giving consent. So the person who is giving consent must be informed about the fact that he or she has the option to withdraw the consent. And a withdrawal of consent applies from the moment on the consent is withdrawn. So the processing of data that occurred while the consent was still in place remains lawful. Following a withdrawal of consent, the companies must erase all personal data and may not continue processing the data of the specific person any further. Where the pharmaceutical company has disclosed personal data has disclosed those data, it must take reasonable steps to inform other data controllers who are processing those data that the person has withdrawn its consent. And the company processing personal data is required to be able to demonstrate that consent was given. So this is the reason why we strongly recommend to have the consent actually in a written form. The regulation provides extended documentation obligations and a burden of proof for the fact that the company processing personal data complies with privacy laws. Following from the regulation, a data controller is responsible for and must be able to demonstrate compliance with data protection principles. In court proceedings, this will usually lead to the obligation to prove that the company processing the data correctly implemented the regulations of the General Data Protection Regulation. Infringements of accountability obligations are threatened with fines, as we heard before. They can be up to 4% of the company's worldwide annual turnover. And data controllers, and to a certain point also data processors, have to implement technical and organizational measures to ensure and to be able to demonstrate that the processing of personal data is performed in accordance with the regulation. They must keep a register on all data processing, including the information on the purpose of the processing as well as its legal basis. So as we discussed before, the consent or the legal obligation or whatever the legal basis in a specific case is. The regulation introduces an explicit right to erasure. The obligations to erasure are broader than currently under the, for example, German Federal Data Protection Act. The company has to erase any personal data without undue delay as soon as a person withdraws consent on which the processing is based. As said before, whether personal data are made publicly available, the companies must inform other controllers who are processing those data about the erasure of any copies or replications made of personal data. There are exceptions where processing is, for example, necessary for compliance with a legal obligation, which requires processing for the defense of legal claims. So whenever you have that case, this would be a matter of further review and proving. If you can keep the data under certain circumstances, yes, you can. So what are the to-dos until next May? Review the status quo of personal data and data processes, and review whether proper consent is given, and ensure that consent procedures your company has comply with the new regulations. Review your privacy policies and procedures, and also assess any data processing agreements your company may have with business partners. And with this, I pass over to Maite, who will give us some ideas on how to deal with the new privacy regulations in case of research activities.
Thank you, Elisabeth. Hello to everyone. I am Maite Vazquez. I am the managing partner of AS Law. It's a Spanish law firm who is working as advisor for biotech and pharma industry. The subject we are going to talk about today is research activities under the regulation. And if you see, there is a subtitle, encouraging innovation in the digital single market. That is because when the regulations come into effect in the spring of the next year, it will try to reconcile the competing values of privacy and innovation by harmonizing privacy legislation across the European member states. It's an attempt to create what they call an European digital single market. And in this idea, it will include some exemptions for scientific, historical, and health research, data processing. That is the subject we are going to talk about during the presentation. Sorry, first of all, we have to define research. Research is divided in three categories in the regulation. We have scientific research, historical, and statistical research. And although all of them are relevant, the most relevant for the pharma industry is the scientific research. This category includes public health research, and we will talk about it a bit later. The thing is that the scientific research is defined in a broader manner, trying to achieve the purpose registered in the European Fundamental Treaty to create what they call an European space where knowledge can circulate freely. This is the idea that is under the regulation. As we will see, the regulation has created an exemption for data processing when research is involved, but there is at least two questions related to research that are pending of resolve. The first one is if private research for technological development must be published to qualify for the exemption. At this moment, I cannot answer to you how this is going to work, because I'm still investigating it. But about the second, that is, what happened with the publication of personal data associated with scientific research, if we have to comply with specific conditions, we have to consider that when we are talking about scientific research, we are going to follow recognized ethical standards, and we are going to take safeguards that are included in Article 89. That means that we have to ensure that technical and organizational measures are in place, in particular to ensure respect for the principle of data minimization. We are sure that the exemption that we are going to be is going to something that we are going to have to talk about in future, because at this stage we have clear that public health research is already exempt, but we don't have a clue if privately funded research is going to follow the principles of public health research. The exemption that we have in this idea facilitate a digital single market across the European Union is say that the research occupies a privileged position within the regulation because organizations that process personal data for research purposes may avoid restrictions on secondary processing and on processing sensitive categories of data. As you see, there is no difference between data or sensitive data. We will talk about what is sensitive data later on, but the idea is that for scientific or historical research purposes or even statistical purposes, the legitimate expectation of society for an increase of knowledge should be taken into consideration, giving place to this exemption where the researchers could do any process of the data without complying with the regulation, even the consent of the data subject. Researchers that process sensitive data, therefore, are subject to the same obligations as researchers that process not sensitive personal data. We will see one distinction is about profiling, but we will talk about later on. Well, the following is to know if research by itself is a basis for processing. The thing is that if we look at Article 6 that Elisabeth explained before, we see that there are a lot of possible lawful possibilities for processing data. We have consent, we have performance of a contract, we have compliance with a legal obligation, we have also to protect the vital interests of the data subject, to carry out a task in the public interest, and the last one, that is for purpose of the legitimate interest pursued by the controller. If you see, research is not specifically included in Article 6. So when we are looking for the consent, we cannot say that research, that processing based on research shall be lawful. Anyway, it's supposed that research can qualify under the last point I said before, the purpose of the legitimate interest pursued by the controller. But there is no any evidence in the regulation including that. What we have in the regulation instead is in Article 6.4 is that data processing under a lawful basis, for example, the consent, allows the researcher to do a secondary research purpose included in the first authorization. What we can say is that at the end, regulations suggest that in some circumstances, research in itself could be the basis for processing. But even if we don't have the data subject consent, but it's not clear at all, and we have to say that it's like a secondary purpose, but not really the primary purpose. How can we comply with the conditions for research exception? First of all, for any processing of data, the regulations include the necessity of implementing appropriate safeguards. Also, as we said before, we need to act keeping recognized ethical standards for scientific research. And also, it seems that regulations give another possibility is that we can work with pseudonymization. That is something that in research is encouraged, but not mandatory. The thing is that at the end of the day, the researchers and the controllers need to know that when we are working with anonymous data, the regulation does not apply, exactly the same that it was previously with the directive. But nowadays, when the regulation starts next May, researchers have to have in mind that even if the data are we are under pseudonymization, and with a reasonable effort, it's possible to re-identify the data subject. This data is going to be subject to the regulation and has to comply with all the rules of having appropriate safeguards and also keeping recognized ethical standards for scientific research in all the data processing that we are doing. About the consent. Elisabeth has explained quite well that we now require an informed consent and an ambiguous consent. These requirements are applicable also to researchers. Also, is applicable to researchers one thing that is included in Article 13 that say that when you are doing a later processing of the data or a new processing of the data, every time you have to contact the data subject to inform him properly of the things you are doing. But coming to research, the regulation relaxes the notice. It relaxes not in the way that you don't have to give the notice or we don't have to have this informed consent, but relaxing it in the content of the information we have to give. We have to point out to the data subject only certain areas of research or parts of the research project. But the regulations understand that in research it's quite difficult to know all the lines that you are going to follow when you are starting research. And that is the reason why the regulation relaxes the notice. Also, it's possible to be exempt from notification when data comes from publicly available sources and trying to contact the data subject is impossible or gives to the researchers a disproportionate effort. Also, it's possible to be exempt when it's likely to render impossible or seriously impair the achievement of the research objective. That means if we cannot get the purpose of our research because giving notice or communication to the data subjects we are going to go against our research, we can be exempt from the notice. But in these cases, it is necessary to keep the trace of what we are doing and what we are doing that, because it's quite relevant, the accountability of the process, the decisions, and the documentation we are keeping in these cases. So, a point quite different from the rest of the areas where regulation applies is the data subject rights and how it's treated in relation with research. Regulation even exempts researchers from the right to give the data subject the possibility of erasure the data from the database. This is only the case when it's impossible or really seriously affecting the research purpose. Also, it's possible that the researcher may override the possibility of the data subject to retain the right to process even for research purposes. In these cases, the researchers can object to this right when it's necessary to perform the tasks that they are carrying out. But in this case, we have to show that this is a public interest in the base of the data processing. It's different from the previously, because in the previously it was we don't erase the data because we are going to affect negatively to our research. In the second is that we have to show that we have a public interest, and in this public interest we are working with the data, so the data subject cannot object to the processing. Finally, the regulation includes the possibility that each member state, well, means that we will have to see what is happening in every country or the European Union, personal data can be, the states can override all the subject rights when we are talking about historical research, scientific research, or statistical research. But we will have to wait. At this moment, what we have in the regulation is only these two possibilities that I have commented. Also with researchers, the regulation is giving more rights than in other areas of or other kinds of data. The first is the possibility of transferring data to third countries. And it's possible to do that under a research purpose, but this purpose must be compelling. Compelling means, in this case, under the recital 113, that there is an expectation of society looking for an increasing of the knowledge. All in the regulation goes through this idea that expanding the knowledge, the scientific knowledge and the general knowledge of the society is the base of the regulation. And when we are talking about research, this is possible under Article 49 to transfer the data to third countries, but we have a limitation. The transfer must be unique. There must be a limited number of data subjects affected by this transfer, and the controller has to put in place suitable safeguards, must to prove that he has or she has these safeguards, and at any moment the data protection agency, the local data protection agency, can investigate this transfer and to prohibit them or to finish them if they don't have, they don't comply with these requirements. Just two last things. One is profiling. Profiling is evaluating certain personal aspects in an automatic way of a natural, with data related to a natural person, looking for an analyze or predict aspect of this person. Mainly in pharma industry, it's not applicable, but because it's more a case of banking and scorings and things like that. But we have to have in mind that sometimes during research we need to do profiling, and if it's involved profiling, we will see that there is a slightly difference between data and sensitive data, but it's possible to do that. But again, there is the necessity of do what the regulation calls a privacy impact assessment. We have to do this assessment previously to use the data for profiling. As you see, profiling on sensitive data is forbidden for the regulation, but is allowed if we have the suitable safeguards and the data subject has given the consent, or we can prove that there is a substantial public interest. What we mean is that we have a set of data that are not sensitive data, we can do profile. If we provide this privacy impact assessment, but when we are using sensitive data, we have to do the privacy impact assessment, but we have to prove also what we have said, suitable safeguards, the consent. In this case, we need the consent for doing that, and the public interest. And finally, coming back to sensitive personal data, as we have seen, this is genetic, biometric, and health data. They are sensitive for the regulation, but from the point of view of research are treated exactly the same that other kind of data that are not qualifying like sensitive data. We can process sensitive data for research purposes even if we don't have the consent. In any case, we need the suitable safeguards, but we can process them, as I said, without consent, and the only limitation is about profiling, that in this case, as we've seen before, we are going to require not only the safeguards, the suitable safeguard, but also the consent and or demonstrate the public interest. That's all from my side. I'm going to pass the control to Ned again.
Thank you, Maite. So you heard some very comprehensive reviews and guidance from both Maite and Elisabeth on GDPR. I appreciate that insight. I think it does raise a lot of questions. It does bring to fore a number of factors to consider. And what I'll do in the next 10 minutes is share with you some of the implications of GDPR from consent management standpoint, both from a business standpoint of factors that you want to consider, and also from a data management standpoint. So with that, let me share a few points and summarizations with you. So from a consent management standpoint, what I want to highlight is that data privacy, as it has been shared, begins to represent a higher degree of sensitivity than data transparency. Primarily and very noticeably is the fact that the data privacy violations are clearly more punitive than data transparency errors. Let me give you an example. An example would be that if the manufacturer makes a mistake in reporting the spend amount, and let's say that mistake is a transcription mistake, 59 is reported as 95. That is a mistake, that's an error, but the damage or the impact of that error and the related penalty is limited. Conversely, if that very transaction is published without consent from the physician, then the penalty and the violation that that represents, which falls under private data and which falls under publication of that private data without consent, that penalty, as Elisabeth shared, represents a very significant risk to the manufacturer. And I encourage, if you have questions, please start sending those in. We will take those questions shortly, but I'll cover a few more points before we get to the Q&A session. Another aspect to consider is managing data privacy as a program, very much with the same vigor and energy as you have invested in data transparency and reporting spend. And I'll get into that in a minute. Also from a process standpoint, data privacy ideally precedes data transparency, especially when it comes to publishing of the data. In other words, you need to have very clear knowledge of which physician has consented, who has not, before you assemble and publish the report. And then equally important, that the regular refresh of the report needs to happen. As you heard very clearly about the erasure and the extent of erasure that's required in the context of data transparency, that erasure would directly apply to erasing that information from your published transparency report. And then lastly, what I'll try to cover in the next few minutes is elements of a consent management program. So let me share those with you. So in terms of elements that you want to consider if you manage consent management as a program, these are a few that I want to call out. First is data security, and that goes to address all aspects from access of that information to storage, retrieval, archival, as well as availability. And in that context, what I want to call out is there are regulatory requirements about the duration of the storage. There are also regulatory requirements about archival. And then lastly, there is a very well-defined criteria in terms of accuracy. And you heard both the experts share very clearly that you want to have a mechanism in place to be able to provide a verification of that information. So all that goes to the aspect of storing information in a very reliable, consistent, and retrievable manner. Second aspect is consent status. Said simply, as an organization, all manufacturers should have 100% accuracy in knowing who has given consent and who has not. and that state of consent should be consistent with your published report anytime and all the time. So that is the golden nugget in terms of managing your program and assessing if your program is successful, is to know with absolute certainty the status of consent for the physicians, and then conversely to be certain that your knowledge of that consent status matches and is fully reflected in your published report on data transparency. Lastly, consent changes, and again, we heard that very clearly, that the process for revocation of consent should be as simple and as easy as the process of collecting consent. So this is again an area I feel where efforts are warranted as organizations move forward in providing A, the ability to revoke consent, and then B, the ability to document it and be able to verify if the consent has been revoked, when it was revoked, and what actions were taken with respect to removal of the information promptly after such a revocation. And then to keep that information intact. Also recognize that with the annual process of reporting, you would have the scenario where a physician gives consent 1 year, revokes it possibly during that year, gives consent the next year, and possibly revokes it again. So you will have to pretty much maintain a chronological record of those activities. And so those are what I imply by consent changes as an important aspect. And then lastly, physician engagement. Throughout this process, I think it is important as manufacturers for us to fully appreciate, and I have a number of colleagues and customers who have expressed this very effectively in how they have shared their efforts to maintain a friendly level of engagement with physician, offer multiple channels to the physicians for both collecting consent as well as managing and reporting that. And then lastly, make the information visible and accessible to the physician, because they are also, as practitioners in this effort to provide care to the patients, an important and very busy element and member from an effort as well as impact standpoint. So lastly, in the next couple of minutes, what I want to do is share with you one aspect about how this process could possibly be managed in a manner where all these aspects of GDPR are accounted for. So I apologize, this would be a bit of a process slide, and I'll try to make it as simple as possible. So one aspect that we know very clearly is the fact of transfer of value. This is where the spend happens, and all the manufacturers today have various sets of processes in place to record the details of transfer of value, and that gets stored either in your accounts payable system, it could get stored in your research application, and so forth. Where the consent now starts to play into this process is the fact that you as manufacturers are now going back and asking the physician to review the spend record or transfers of value. Then you're looking to second receive consent from the physician to publish those records. And third, you need to again account for the ability for a physician to correct any spend records, revoke, or deny consent. So that's the first aspect that you as an organization may have already implemented. Some of these processes are pretty much paper-based today, but something to consider in the context of some of the functional elements I shared to make that process more robust and digitized to the extent possible so that you can maintain those records over a longer period of time. The second aspect to this is administration of these. In that context, you want your organization to have the ability to administer this information, where you have someone who can perform all these functions on behalf of a physician, where you receive this information by mail, by phone possibly, through email of course, so that you can then track all those forms of input coming in to approve corrections. So of course there's a record of spend that you have, and then there's a record of spend that the physician claims was the case, then someone has to be in a position to review and approve those corrections. And then lastly, user management. If you provide this visibility to the physician through the web or through other online interface to allow the management of that interaction with the physician. And then lastly, publishing the updated report. Again, the goal is that the state of consent should be fully and always reflected in your final report stage. So those were some of the key points I wanted to share with respect to process. And then lastly, I was asked a question earlier about some of the functional features to consider. I called that out, that you need to have secure access, physical as well as virtual security for access. Your data needs to be secured. What that means is it needs to be backed up so that in case there is any loss of data, you have the records available. Again, a lot of rigor is required because the level of impact is very high. That comes into disaster recovery aspect, data storage scalability aspect, because the level of information you need to store now with various states of consent and revocation needs to be supported. The idea of central repository, and that idea stems from the fact that any region, any country, any physician may challenge you with respect to your state of consent and the publication of that record. And it would be a challenge if you were to maintain several different paper, automated data, and digital records. So a centralized mechanism would serve you well in terms of both management as well as accuracy of that data. And then lastly, ease of access. There are several mechanisms available today for you through which you contact and manage the relationship with physician. It is important that you offer some of those avenues because there was a question I noticed about how to manage and increase the level of consent, and ease of access would go in and play in that space. So with that, I would like to encourage all of you to share your questions if you have. I'm going to ask my colleague to share with me any questions that have come in so far, and I will play those back to our two experts, Elisabeth and Maite. So let me just quickly look at the panel and see what questions have come in. So the first question I have is a question around right to erasure. And the question is, how will the right to erasure impact records already published in the FPR report? Elisabeth, you touched on that topic, so if you wouldn't mind taking that up.
Sure. So right to erasure. So the right to erasure means that the person who gave consent can change his mind and can withdraw the consent, and then can also claim that you remove any information about that personal data that was previously published. So that's the erasure. And the important is that when the person withdraws the consent, the previous disclosure of the data, for example in the FPR, under the FPR disclosure obligations, is still admissible. So this does not become unlawfully with view to the past, and with view to the future, you have simply to remove that information. So you should remove that information also from the former FPR disclosures. So that's what we would recommend. And if you have it not on your own platform, but on a central platform, then you should reach out to the provider of the central platform and inform the provider of the central platform that the consent was withdrawn and that the physician wants to have the information about him erased, and then that platform provider should erase any information from the disclosure reports.
Okay, so just to summarize then, Elisabeth, what you're saying is that the erasure is to the extent of the report itself, there is no erasure required from the internal data where, of course, the transaction has been recorded in an accounts payable system or such.
Yes, you don't have to erase it from the internal. You just may not disclose it anymore.
Okay, thank you. So the second question again has come for you, Elisabeth, so maybe you're doing a little double duty today, but let me read the question. The question states, could Elisabeth please expand on what might be considered as a reasonable steps in terms of the requirements to follow up with the other data controllers under a right to be forgotten request where personal data has been publicly disclosed, and the references to Article 17(2).
Yes, so did you just mention an article, 17(2)? 17. Okay, I see. It has to be reasonable steps. Well, reasonable steps is a very general term. We have to somehow fill it with life. So what reasonable steps do you have if usually you somehow cooperate with somebody? If you you have to reach out to your business partner, you should be aware who this is, and then you must take any steps that you can. So you must think of what actually you can do. So you can reach out to him, you can tell him what to do, you can ask him, please remove this and that information from, for example, the central platform. And but of course you cannot erase it on your own. So if that other person just does not do it, that's out of your influence. So you have to do anything that is within your area of influence and encourage your business partner to remove that information.
Okay, super. So we have another question that has come in for Maite. So Maite, the question is, what is the impact of GDPR on EMA Policy 70? Currently, we are anonymizing retrospective clinical data, wherein informed consents from participants must have been taken years ago, and that too for intended purposes of the research. However, as EMA will publish all these documents after anonymization, and these could be utilized for secondary analysis, does this mean that there will be changes in the informed consent process for prospective clinical studies?
Well, I don't think that it's going to change very much what we are doing at this moment. I think that the idea is that in those cases that we are getting personal data from the subject at clinical studies, we are going to inform them. The thing is that under the regulation is that if you forget to inform them in some way, and you are doing the clinical studies and it's just for research purposes in that moment, my understanding is that regulation is giving you a partially exemption on these purposes that you are not informing. But at the end of the day, as I was saying before, we have to if the primary purpose of getting the data and collecting the data is research, we need the consent. This is by sure. The idea is a relaxed consent because you don't have to put in all of them the information is required or all the purposes or all the lines that you are going to investigate or all the things you are going to do with the clinical data. You can relax a bit. But apart from that, nothing more is going to change.
Okay,
this
great.
is my understanding. This is not, the regulation is not changing too much from previously situations about the consent in clinical studies. It's more for research purposes, not only for, not when we are trying to prove medicine or we are trying to prove a medical device.
Okay, very good. Excellent. Thank you. So we have just about 1 minute left. What I would like to do is offer that if any of you have additional questions, please feel free to email those questions in. You see my name up there. My email address is ned.mumtaz@qordata.com. We will make sure to share those questions with our esteemed panelists, Elisabeth and Maite, and get back to you. I also want to thank Elisabeth and Maite for their very informed information and session today. Thank you so much, and also thank you everyone for attending. With that, we will close out the session. Thank you and bye.